Hi, everyone. I just want to play the clip of the judge speaking in the Lauren Matthias hearing about this stalker, which isn't a stalker. The judge makes it very clear right here. Here is the clip at the end of the hearing when the judge specifically says what this is and that this is a freedom of speech issue, and being mean to somebody online is not stalking. Here you go.
Obviously, it seems like your client's primary concern is that this impacts her ability to make a living.
Yes.
And her free speech rights.
Yes, Your Honor.
Talk to me about the free speech rights. How does this impact her free speech rights?
Yeah, so with that, Your Honor,
and I read your case law. I want to know factually what in the stalking injunction prevents her from saying what she needs to say. Go ahead.
Sure, Your Honor. Well, so, and we don't believe that it does, but petitioner has alleged that by posting videos, again, without using the petitioner's name or her likeness, that she has violated the temporary order. Now, the amended temporary restraining order does say to keep off online. The respondent understood that to be do not contact her on TikTok, do not contact her on Instagram or on any other platform. The allegation is simply by referencing, making a post that's related to the petitioner online, that she's somehow violated the temporary order. There's 3 videos that they claim have already violated it. That's 3 of the 6 alleged violations that they're prepared to talk about today. And so there's got to be some clarity there. That just doesn't jive with Towner or with Fischler. Certainly the First Amendment allows talking to third parties or the public about somebody. That's Towner v. Ridgway. That's been the law for a long time. Fischler reiterates it. It's just plain letter law in Utah. She hasn't communicated through these posts to or specifically directed at the petitioner. And for that reason, I mean, she's basically gagged online at this point, according to petitioner. Now, we're hoping that the court determines and agrees with us that you can't interpret the amended temporary order that way, but certainly they've alleged that on the language on its face that she's not allowed to go online and to post anything related to the petitioner. And obviously that's got First Amendment issues, and practically it's unfeasible. Everybody goes online and everybody can comment with their friends. Instagram, TikTok, those are ways that we communicate these days, and certainly Ms. McCoy is entitled to communicate to her friends and followers via these online platforms. And it's simply unfair to go another 3 weeks just allowing petitioner to collect videos that have been posted that are First Amendment protected and bring them and use them as a cudgel when we get finally to court for the full hearing, which we thought was going to happen today.
Okay, thank you. Go ahead and respond.
I have to object to the characterizations he's made on behalf of myself or my client and our positions. The evidence, like we're getting lost in weeds. The motion he made was based on the declaration, the testimony we've heard in the declarations, that the court should suspend the temporary order. But there is no evidence to suggest that. Like, that's not the question. The question, Your Honor, is whether or not my client has the burden to prove that it should continue. There's been no motion to set it aside at this point. So that's improper. That's not properly before the court. The rest is just argument and representations.
Why would he file a motion to set it aside? He thought he had a hearing today to deal with it in full.
Well, I'm just saying procedurally. There are procedural ways to do that. Those haven't been met. Satisfied. The other arguments about what's been said online or what they're about have yet to be proven and shown. Virtually all of what he said is not based on evidence that is before the court today. So the court can't make that ruling today.
Okay, thank you. Go ahead.
Yeah, and with that, Your Honor, this is a motion, and we're making it. We learned minutes ago that this is going to be extended for another 3 weeks, and this severely impacts respondents' civil rights. I mean, this is what we have. I mean, at a minimum, we need a clarification for the amended temporary order that that makes clear that she's entitled to go online and talk about whatever she chooses to talk about online, and that certainly can't be a gag order, that it has extended that we're going to be on for a motion for sanctions about, and then that's going to go for another 3 weeks now.
Your Honor, I would object to the characterization of the language of the civil stalking injunction itself. It's not what he represents it to be.
Well, I'm reading it.
It's
So I
in-
can, and it's my order, so I'll make the interpretation of it.
Sure.
Okay. I do have, I'm not sure how this was interpreted, but let's go back to the purpose of an ex parte temporary order. That is to stop any harm. Specifically, we're looking at ongoing threats or physical harm that could happen. It's made without all the information. It's made simply, basically from one side, providing the information. As the ex parte order right now, it prohibits personal contact and prohibits threatening, annoying, stalking, harassing. That will remain in place as is. As to the no contact order, that will remain in place. Specifically as to the text, mail, email, or any other communication directly or indirectly. In other words, I don't want them talking to each other. Now, it does identify other people and family members for sure. So Mr. Matthias is sure going to be covered by that. As to Grace and Yor, is there any reason that your client would need to contact Mr. Yor?
Miss Yor, but no.
Oh, excuse me, Miss Yor, thank you. Okay, then Miss Yor's included on this. Son is covered by this. So that will remain in place as well. As far as the stay away order portion of it, stay away from her home, that will remain in place as well. Is there any reason why she would need to go to near a job site or a school of Ms. Matthias?
Well, no, but just to clarify, I mean, there's public places where they both may
I'm going to
think-
deal with that.
Okay, so no, not in Henderson, Nevada.
Okay. And then I think this is the provision that may be misinterpreted here, that she's prohibited from online forums and social media accounts. But that was in kind of in parentheses, TikTok, but then it says down there the 2025 CrimeCon Expo that was in Denver, Colorado, September 5th through 7th. When I was reviewing this, that was what I was looking at, was that CrimeCon. I in no way intended that the respondent was to be kept off of social media sites. I do think that's freedom of speech issues, and I don't think that this order was intended to cover that. So she can get on those now. I guess she runs the risk if she's on those and those are interpreted as annoying or harassing, although I will say that's a fairly high bar in the sense of just because somebody says something you don't like, that's not going to be a violation of a stalking injunction. And there would have to be directed comments that were clearly meant for a specific purpose. Yeah, there was, in obtaining the order, petitioner made some allegations that she had strong belief that she was in immediate danger in relation again to the CrimeCon that was in Denver, Colorado. Now, as to the work environment, it does sound like the parties may attend similar court hearings. I'm assuming court hearings. Is there any other public buildings where they need to be in the same spot?
Well, the accompanying press conferences and other kind of public places is what we're talking about.
Okay. As to those, I do think that this order is not intended to stop Ms. from working.
So I would object to that characterization, Your Honor.
Which part?
Sorry, the respondent doesn't work at courthouses. She's not a criminal investigator. My client is. So the representation that they need to appear in public, they may appear in public places based on her employment is not accurate. She has no employment in this field.
I think it's not disputed that they're public places. It may be in dispute whether they consider her to be a professional in this field. We certainly do call that a disputed issue, but it's not disputed that they're public places.
What does she do?
She takes photos.
She's a photographer.
Yeah.
She's not a photographer for the court?
Hold on.
Sorry?
Well, that's true. She's a freelance photographer, and she also is, like everybody, trying to make her way in this true crime industry.
Well, and I have freelance for
Okay, that's right. She does freelance work for some national news outlets you would have heard about.
Okay. Yeah, let me address the public place argument first. That doesn't fly because stalking injunctions often cover public places. However, it does sound like she has a right to be there and she's got a purpose for being there. And if that's the case, if she's there with a purpose, then she can be there. The order is that they will keep, that she will keep her distance because Ms. Matthias, she's not a respondent, there isn't a counter one. So Ms. is required to keep her distance from the petitioner. Now, it's hard to say exactly how far that is because it may be different if we've got a media scrum or something and we're taking photos, then it may be closer. But she certainly cannot be right next to her. She certainly can't be making faces to her. She can't be making gestures. She can't be making comments. None of that can occur. If they're in a courtroom, like a courtroom here today, I'd expect that they would be on opposite sides of the courtroom. So I expect to receive a modified temporary civil stalking injunction with those changes incorporated.
Your Honor, if I may, I'm sorry. There is actually one more place where the online stuff and the social media, way down at the bottom with other relief sought, is actually where I was quoting from earlier, where it says that she's not allowed to post relating to or referencing petitioner. And that's, I think, one of the things that we need to clarify.
Where it says respondent shall cease and desist any and all online activity and communications relating to or referring to the petitioner, her immediate family and extended family members.
Is that portion subject to the court's clarification on the other bit that you just made?
Yeah, now I think I was clear before that I expect her not to post anything necessarily that she's running a risk. If she posts something negative about her, that's something she can, I guess, theoretically do. But she needs to be careful in walking that line.
Is there any clarification you could give us on what might be qualified as negative?
Well, if she's threatening her, again, we have to go back to the purpose of a stalking injunction. If she's threatening her, if there's a harassment that would cause emotional harm. I mean, all of us run the risk that somebody's going to say something bad about us. Whether that turns into harassment I think that's a high bar.
Is there any evidence?
Let me be clear on this, Mr. Dale. This civil stalking injunction was in no way meant to silence what Ms. is doing. And I want to be very clear on that. And any permanent stalking injunction will not be for that purpose. That is not what a stalking injunction is for.
I guess I'm looking for clarity on what it is the court is basing its ruling on when it says what she does or what she's doing. And
what do you mean?
So the respondent isn't a true crime investigator. She's a photographer. She has an art channel on Instagram. She has separate media accounts, social media accounts that discuss solely the flaws of my client, to air them, to cause her harassment. I guess I'm not sure that, but we haven't had a chance to provide all that evidence yet, so we'll do that at the next hearing. My concern, though, is that based on just the testimony today, that has not been challenged or refuted, and so there is still an outstanding concern that the activity we've alleged that is happening online and in person and to other contacts has not been refuted properly and is not.
I'm not making a final ruling. I'm making
Well,
a temporary order.
so the order, if the order is to remove this online protection from specific directed, harassment, embarrassing things that would cause my client emotional distress, I guess that's what I'm looking for clarification on. Is the court withdrawing that based on something it saw today? Because there isn't anything we've seen today that would refute.
Well, I think what the court is looking at is we're trying to get more clarity than a one-sided order that was initially signed. That was based on one-sided information.
Sure. And we don't mean to interfere with her public or First Amendment rights. But to the extent she has made specific channels titled objection, Your Honor, that are not my client, we would ask that protections or restrictions on those accounts be held in place until we can have a full hearing. That seems to be
directly a freedom of speech issue.
They're directed at my client.
Right, which is a freedom of speech issue. You can say things about people. We may not like them, but we can say things. What she's prohibited from doing, let me be clear because you're asking for clarity, she cannot threaten. She can't threaten her physically or her family. She cannot defame her. If there's a defamation, then that's something that's illegal and would fit under a stalking injunction. I think that's what we're looking at is that she can't do.
I can represent to you that there are many, many videos that defame my client.
Okay.
So I would ask that temporary protection be in place until such time as we can review, the court can review the defamation nature.
Well, I think what I'm going to do is I'm amending it saying that she won't threaten. We're going to be very clear online. She won't threaten. She won't defame. Okay?
Thank you. Whether online or other.
Well, she's not talking to her in person. I expect zero communication as far as she can't talk to her, she can't email her, she can't text her. Mr. Dunkelberger, I want to be clear, she can't do that through a third party. She can't send a message through a third party. There is to be no communication there. The other parts of the civil stalking injunction remain intact as well. I don't want her near her house.
Does the 500 feet specifically remain?
Yes.
Oh, thank you.
Yeah, no, as to her house. Now, like I said, the only exception to the 500 feet is if they're in a public space that they cannot be 500 feet apart. And then I expect them to be as far apart as reasonably possible. That's language I want in there, Mr. Dunkelberger.
Yes, Your Honor.
But otherwise, that is 500 feet. So Mr. Dunkelberger, if they're in a mall, your client needs to move away 500 feet. If they're in a restaurant and if your client comes in second, then your client needs to not go in and needs to leave.
What if it's the other way around? What if she was there first?
Well, and why would your client go in if she's worried? Maybe she's worried about her health if she knows her there.
That's the key. If she didn't know she was there, but the respondent says, "Well, I was here first," what should my client expect to do in that circumstance?
Well, I would expect if your client is worried about her safety, when the reason we got a stalking injunction, and she goes in there, she would leave. Now, if by chance we've got Ms. McCullough is in there, I'm assuming your client's not going to go over and approach her. I'm assuming Ms. McCullough is not going to approach her and that she will leave, provided she's finished her meal. But I expect that there would be no communication, there would be no, again, facial gestures, anything of that. They'd finish their meal, they'd go on their way. We got to be careful how we're using the tools of the law in this courtroom. And I expect the parties to use common sense. Okay, Mr. Dale, anything I've missed on you that you want else addressed?
Let me review the language, Your Honor. Oh, these clarifications you're making, I assume they apply also to the other protected individuals, her husband, her son, co-workers, etc.
Went through that, yep.
Okay, I think we did. Professional associates, other known professional associates of my client. Can we retain that language?
They're not covered under this list. So no, so you can have contact with them. What I did prohibit is third-party communications. You can't send a message through one of them.
Understood. With respect to,
Go ahead.
sorry.
Finish up.
With respect to the online posts, I think that's the biggest concern for my client. In addition to defaming statements, is there any other clarification the court can give on what would constitute a defamatory statement? So that there's no argument. So there's no like.
What's legally defined as defamation? It's got to fit the legal definition.
Okay. What about harassment?
I don't know what that's going to qualify as, and I can't get into everything. I would say, Ms. MacArthur, I'd be careful in the way you do that. But again, if she's just saying negative stuff, this is not, again, a stalking injunction is not a remedy for shutting down speech that a person doesn't like somebody saying about them. And it seems like that's what you're trying to do in this case.
Well, again, Your Honor, I would argue that we're not asking to restrict her speech. She can still go anywhere else.
That is speech. Online speech is every bit as protected as anywhere else.
Some forms of speech, like threats and defamation, are not protected.
And that's what I put specifically.
And if that's the best we can do, like that's most clear we can be, I understand. I just thought I'd ask for any additional clarification you can give to be instructive to both parties.
Yep. Okay. I think I've been clear on that. Mr. Dunkelberger, anything from your side?
No, thank you, Your Honor.
Okay. With that, we'll plan on seeing you. We've got 2 witnesses. I will just save the time. Outside of the parties themselves, if you've got out-of-state witnesses, they can attend virtually unless they're going to be presenting hard evidence. In other words, documents or some other type of physical evidence. If they're going to be doing that, I want them here because it gets real confusing with the technology. And so other than that, if they're out of state, they can appear remotely.
Thank you.
Thank you, Your Honor.
Okay, we will be in recess. Thank you.
All rise.